Okay, constitutional remedies. Constitutional remedies only apply when we're dealing with a direct application of a Bill of Rights issue in the context of the Constitution. So no indirect application. In direct application, we find our remedies in the enabling legislation or in common law. So, Section 38 deals with the remedies in cases of direct application. They must be distinguished from ordinary legal remedies, which you know flow from indirect application. Section 38 is the enforcement of rights. Anyone can approach for appropriate relief, including a declaration of rights. That's what Section 38 says. So let's talk about declarations of constitutional invalidity being one of our first remedies. When deciding on a matter within its power, a court must declare that any law or conduct is inconsistent with the Constitution and the extent of that inconsistency. It may, if a court finds that something's invalid, it must strike it. It must declare that it's inconsistent. But it may make further orders that are just and equitable. And these include an order limiting the retrospective effect of the declaration, an order suspending the declaration of invalidity for any period. And I've already discussed that is to acknowledge the separation of powers and give Parliament, our democratically elected body, time to make laws that cure the defect. So the Supreme Court of Appeal and the High Court may make orders, make an order of a similar status concerning constitutional validity of an act of Parliament or conduct of Parliament, but an order has no force or effect until it's confirmed. So your first hurdle is going to a lower court, getting an order of for the declaration of invalidity. It means nothing, and I mean nothing, until the Constitutional Court has confirmed it. And that's not an automatic sort of rubber stamping process. The Constitutional Court will deeply consider the merits and and provide a judgment in accordance with that. It's not an automatic question. So your first hurdle is by no means your largest hurdle. A court may make an order of constitutional invalidity and grant a temporary interdict to provide relief depending on the circumstances of the case and what relief is needed. But the declaration of invalidity, as I said, is not discretionary. A court is obliged to do so. This is a strange one, but it's a great one in terms of being able to demarcate the Declaration of Rights and demarcate where those have been infringed. The courts are in a tight spot there, and I think it's fabulous that if they are with you, if your argument is cogent enough that they're with you to the extent that there has been an infringement, they don't have discretion to find that the conduct or legislation is invalid. That's an excellent thing. Okay. But the controlling of the invalidity so that we don't have uncertainty in law is that limitations, that suspension question. So the courts can limit the retrospective application, suspend the invalidity, and the courts respect that separation of powers, as I keep saying. Other remedies are things such as severance. So law or conduct can be declared invalid to the extent of its inconsistency, particularly sections, can be declared invalid while the rest of the legislation remains intact. This must be possible in order to sever the good from the bad and keep good law. We don't want to throw the baby out with the bathwater because we elect Parliament, they create laws. We don't want to throw out all the law for no reason, just because one section is invalid. If you think about contracts, you have a severance clause that says, if something needs to be severed, we only sever the bad bits. This is the same thing, but with legislation. Then we've got reading in, which is the opposite of severance. Reading in is used when the inconsistency is caused by an omission, and it's necessary to add words. Reading in will also have limited application. It's sort of where it needs to say he or she. or owner or interested person. There's going to be interesting reading in the new Companies Act, because there's a question about whether or not third parties can sue directors of a company for personal liability, piercing the veil. It's kind of been removed a little bit in the new Companies Act, and there's been some case law, but not confirmed at a higher court, about what's going to happen with the ability of third parties to sue directors for breach of fiduciary duty. It's not constitutional per se, but there are constitutional arguments to be made there. It's an example of reading in. Other forms of relief include interdicts, constitutional damages, contempt of court, exclusion of evidence, remedies in terms of admin law, and remedies in terms of labour law. So with interdicts, I want you to remember that interdicts are either orders stopping someone from doing something or compelling someone to do something. We've got ordinary interdicts, then we've got supervisory interdicts, and then we've got mandamus. So a supervisory interdict is an interdict where the court says, you must do something and then report back to me that it's been done. A mandamus is the same thing, but specifically against the state. The court orders a government department to do something and report back. They're very rare in our law because, again, courts want to give respect to the separation of powers, and a mandamus will only really be ordered when it is shown that a state department is incapable of doing it without supervision. Whatever the interdict is, that's what it is. With regards to constitutional damages, they can kind of be seen as a mythical creature. You can read the Fosse judgment in terms of when the court thinks constitutional damages will be appropriate, but the court has said the constitutional damages are only appropriate when no other relief is available, and the damages asked for is on the basis of the infringement of a right. It hasn't happened. It's very rare. We don't know when it's going to happen. But there is a case before the Constitutional Court currently. Arguments have been closed. You can watch those arguments on YouTube about whether or not constitutional damages are warranted for a community in the Tembisa township who have been waiting for housing for 20 years, where a lower court has ordered the municipality to provide these specific closed group of people with houses, and the municipality has failed to provide those houses and failed to budget for them for at least 3 years. So this group of people, their right to housing has been infringed. They're now asking for the Constitutional Court to decide whether or not they're entitled to constitutional damages. So they're not entitled to any other form of damages. So read the Fosse case, and then read the the Tembisa occupiers case, or watch it rather. There's nothing to read yet. There's no judgment out. It's interesting times we're living in, I'm telling you. So I'm going to pause now and then talk about constitutional court rules.